Good afternoon, ladies and gentlemen. I'd like to welcome you to the Business Utility Subcommittee. Today is Tuesday, March the 21st, 2023. It's 2 p.m. I'll detect a quorum. I'd like to call this meeting to order. Mr. Clerk, can you take the roll, please?
Representative Alexander. Burkhart. Clemens. Freeman. Hale. Holsclaw. Johnson. Marsh. Thompson. Vaughn. Vital. Zachary. Chairman.
Here.
Chairman, do you have a quorum?
Thank you, Mr. Clerk. Members, before we get started today, do we have any personal orders? I do. I'd like to take one. I actually have a constituent with me today, a friend, Miss Helene Cash. She's the Area Vice President for the Republican Women. If y'all make her feel welcome, please. Representative Clemens, you're recognized.
Thank you, Mr. Chairman. I just wanted to recognize my very charming floor leader, Representative Bill Beck's birthday is today, I believe. Vote kindly.
Happy birthday, Representative Beck. Members, do we have any other personal orders? If not, let's go ahead and get started. We have a few housekeeping items today, and item number 3, that's House Bill 682, has been rolled to the first calendar of next year. Item number 6, House Bill 655, has been rolled to the special calendar. Item number 8, that's House Bill 286, has been taken off notice. Item number 9, that's House Bill 280, has been rolled to the special calendar. Item number 10, House Bill 1067, has been taken off of notice. All right, members, that brings us to the calendar, and we are going to go out of order real quick. Which one? Which number is that?
It's first on the special calendar.
Okay, I'll cover that. We'll get there. All right, so let's go ahead and take up item number 5. That's House Bill 753 by Chair Lady Littleton. We have a motion. We have a second. Chair Lady, I do not see any amendments, so you are recognized on your bill.
Thank you, Mr. Chairman, and thank you for taking me early. I cannot be 3 places at one time, so I appreciate it. This bill would add a self-employee to insurance that is provided by Board of Commissioners, the ones that already get their insurance. This would add self-employed people to it.
Okay. Thank you for that explanation. Members, you've heard the explanation. Do we have any questions for the sponsor? Seeing none, members, we're voting to send House Bill 753 to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it. Chair Lady, we'll see you next week in full commerce.
Thank you.
All right, members, that brings us back to item number 1. That is House Bill 1136 by Representative Miller. We have a motion, we have a second, and Representative Miller, I see an amendment. What drafting code are you showing?
Thank you, Mr. Chairman, members of the committee. Let's start with 6057.
Okay, that's what I'm showing. Do we have a motion and a second on 6057? Okay, we do have a motion, we have a second, and you're recognized on the amendment.
Thank you, Mr. Chairman. House Bill 1136, what the bill does is to eliminate...
Actually, hang on a second, Representative Miller. Let's go ahead and get that amendment on the bill, members. We're voting to put Amendment 6057 on House Bill 1136. All in favor say aye. Aye. All opposed say no. The ayes have it. Okay, Representative, we're back on your bill as amended.
Thank you, Mr. Chairman. What the bill does is eliminate the requirement for the mayor or county executive to sign the application for a consumer permit to sell fireworks in a county or municipality where fireworks are already being sold. This is a very outdated statute since the 1950s. And with that, putting it into questions, and Mr. Chairman, it's my understanding that there may be some individuals that may want to speak on the bill. Is that
let me see real quick. Okay. All right, members, without objection, we're going to go out of session, and we'd like to invite Ms. Melissa Bast up to testify. And Ms. Bast, if you'll just be sure to make sure your microphone is turned on and state your name for the record. And you can have a seat at any of the places there.
Thank you, Chairman Boyd and members of the committee today for your time. My name is Melissa Bast, and I just wanted to speak briefly on the bill. I have owned a professional company and a consumer company here in Tennessee, and I've actually became a lobbyist because I worked with the ATF in Washington on a professional accident, and I came down here then to Tennessee and wrote the professional licensing code for safety here in our state. But when I went into the consumer business, I found our state code was very much broken. It was written in the 1950s, and it is based on population, which no other state in our nation based the sale of consumer fireworks on population. However, we're not here to fix that today, but I wanted to give you a little history on how broken our state code is. I have worked in the consumer industry, and I have manufactured, distributed, wholesaled, retailed, and I've done so in 50 states, including our great state of Tennessee. And in 8 countries. I worked with brands such as Duck Commander, Elvis Presley Enterprises, and Marilyn Monroe. I've gone to China and worked with those brands and distribute them in several different countries. However, because of our Tennessee code, I could do that all over the country and all over the world, but I could not sell in my own county because one mayor would decide if they wanted to sign my permit, and another mayor may decide they did not want to sell my permit. All in 20 years, depending on who was in political power in that municipality I lived in or that county. So I'm here to just simply ask you a question. What other business in our state requires a retail business to require the mayor or the county executive to sign their permit for a state fire marshal's application? The state fire marshal's application is not the problem. It is the requirement of a mayor or county executive in order to do just business, in order to just retail business. And I thank you for your time.
Thank you, Ms. Bass, for your testimony. Members, do we have any questions while we're out of session for Ms. Bass? Speaker Marsh, you're recognized.
Thank you, Mr. Chairman. And my question would be, in the county that the mayor has to sign, is it already legal for the fireworks to be sold there by the governing body or by the rules that are there already?
It is not legal in that particular municipality. There are several others in the state that have grandfathered themselves in either through locally or through the state code.
Speaker Marsh. Members, any other questions for Ms. Bass while we're out of session? Chairman Vaughn, you're recognized.
My concern with this would be, number one, I understand why a chief executive officer would want to know, given the fact, the nature of fireworks, given the simulation to firecracker going off versus gunshots. I can understand if they know whether or not they're going to be selling these products in their area. Could this be used as a bypass? Because I understand some people, I think the proper land use term is a non-conforming use. It's not really grandfathered in as that it's allowed because at the time that they started off, it wasn't allowed to be there. But what I'm concerned is would there be any way that a local government would be notified that someone was about to sell fireworks in their community, either legally or illegally, if we take the requirement for signing this permit off?
Ms. Bass.
If it goes to the state fire marshal, how would a local know that someone was applying to sell in their community?
It has to be already offered for sale in the community. The state fire marshal, it has to be offered or permissible in the community already for the fire marshal to approve the application.
Chairman Vaughn.
it still has to require a fire marshal's approval.
Right, I guess I'm sorry, Mr. Chairman. I guess I'm more concerned about it from a land use and city ordinance perspective more so than I am about the fireworks, about the state fire marshal, but that's,
And Chairman Bond, they can still come up with their own ordinances, and they can be even more stringent than the state fire marshal's requirements.
Chairman Vaughn.
no, I'm good, thanks.
Members, we're out of session and we're hearing from Ms. Bass. Does anybody else have a question or a comment? If not, Ms. Bass, appreciate your testimony today. And members, we are back in session and we are back on the bill as amended. Representative Miller, recognized.
Thank you, Mr. Chairman. Mr. Chairman, this particular bill has been around for a while. At one point, if I'm correct, former Representative DeBerry had the bill. What I'm seeing in this bill, based on the historical perspective, it creates a monopoly where, let's say Lakeland, if it was pretty much where this bill is targeted, if the mayor has been signing off on an annual basis to a particular company for years, what does that establish? That's establish a monopoly where the mayor can pick and choose winners and losers. Should a mayor have that kind of authority or power? That's my question to the committee. If not, currently they have that, but we can remove that monopoly power and the ability to pick and choose what small businesses can operate within their municipality. And that's basically all we're talking about here.
So Representative Miller, question. So across the state right now, in any municipality, would they have to have the mayor sign off to sell fireworks?
It's my understanding there may be a few municipalities in the state under the same circumstances that's in Lakeland, where you have the mayor having that ability to sign off. Now, I don't know which communities or cities that operates in, but let's just assume that if the mayor's got that power and they got relationships, then I would assume the same company that's been operating in the other municipalities under the authority of the mayor continues to happen.
Speaker Marsh, you recognize.
Thank you, Mr. Chairman. And does the mayor, do the mayors normally let more than one person, one company sell fireworks? Or is it just up and depend on what they feel that day, or how the safety record is? I guess if the fire marshal's got to sign off on it, they've all got to be proven to be safe.
Representative Miller.
I would think so, but again, let's go back to the fact that if the mayor is signing off on a particular company, year by year by year, the question is, how do you break that up to do exactly what you're suggesting, that other companies can come in? But if the mayor is picking and choosing winners, then that's where the problem could very well be.
Members, do we have any other questions for the sponsor? Chairman Zachary, you recognize.
Thank you, Mr. Chairman. Representative Miller, can you give us a specific example where this has been a barrier to entry to a company? I'm still just trying to understand how this is limiting a company that wants to sell fireworks into a community. Are you saying the mayor in the community has a particular relationship with an entity, and then he is not allowing other entities to come in, and we're looking at this bill for one particular circumstance?
Representative Miller.
That's pretty much exactly what I'm saying, that you have that kind of monopoly type of activities that's occurring in a particular municipality. But this bill would say if it's occurring anyplace else, then we can remove that temptation from that particular mayor. And hopefully it would, in a positive sense, impact any other municipality that's doing the same thing.
Thank you. Thank you, Mr. Chair.
Chairman Vaughn, you recognize.
I've got a little bit different spin on it. But in speaking to the chairman's situation, because not every one-off situation is created the same way. And it seems to me that this might be getting into us to satisfy or trying to arbitrate a local land use decision, because if a local municipality had approved the sales of fireworks in their municipality before they perhaps banned them, then the people who were selling them before is the non-conforming use that I spoke of. And so what I would hate to see us do is basically resolve a local land use and zoning matter for a single community based upon whether or not this law prevents it, even though it's an antiquated law. But that would be what I would hate to see this do, is be a usurp of a local zoning matter. And that's why there's one person that has to get his permit signed off on. The mayor will only sign off on the non-conforming use, not everybody that comes through the door. And so that would be my question in this case.
Representative Miller.
Listening to the chairman when he said antiquated, although it is an antiquated law, I would just say, I agree with you. It's antiquated. That's probably why we need to change it.
Representative Clemens, you are recognized.
Thank you, Mr. Chairman. I'm excited to hear my colleagues talk about the fact that the state does not need to get into local zoning matters. However, this sounds to me like a bill that promotes small businesses, promotes competition, promotes governmental transparency, and promotes free market competition. So correct me if I'm wrong, but that's what it sounds like to me. Thank you, Mr. Chairman.
Members, do we have any other questions for the sponsor? And I just want to reiterate, I kind of agree with my chairman from Collierville. I hate to take away the executive's discretion in signing off on these things, taking that signature option away. So I appreciate what you're trying to do, but I'm not sure this is the right method. And I had mentioned to Ms. Bast earlier that there may be another way to accomplish this, but I'm not fond of this particular idea. But I'll give you the last word, Representative Miller.
And Mr. Chairman, thank you for that. And how could we come up with language or amendment to, and it was open and mentioned by my colleague, and thank you for your comments, I couldn't have said it any better, that it's in the best interest of small businesses. It becomes competitive, competition, opportunity. And how could we break that little, as I call it, little monopoly up? How could we do that? And I guess that's a question I'm posing to the chairman, Vaughn, and to the committee members.
Chairman Vaughn, you recognize.
Yes, and what I want to find out, because if we remove, basically what your bill is requesting is that the mayor does not have to sign off on the permit from the state fire marshal. So then does the state fire marshal's approval of the sale of these fireworks, does that automatically vest the rights of the entity that's requesting this to do that, or they still have to receive local approval? That's because there's two separate things. This bill contemplates no executive signature. And the thought process being, well, if I don't have to get the mayor's signature, then it'll be easier for me to be able to sell my fireworks. But if I assume that's the case, because that's what we're talking about. This is what a case where an entity is bringing this forward because they want to do business and they can't do it there. It's a barrier to entry. So is the only thing keeping this entity from operating in this jurisdiction the chief executive's signature? Is that all it is? Or so if that's the case, then the state fire marshal usurps all local codes? I'm trying to figure out the relationship there. Could you help me with that?
Representative Miller.
Well, good question, but in your comments, when you mentioned the fact that, yes, that local mayor makes that decision of what entity will operate fireworks. That's true, how that happens. But if you remove that, and that's a good question, what does the state fire marshal, what is their involvement at that point? Which is a good question.
I can answer that.
We are in session right now. If we,
Mr. Chairman. We'll have a session to answer that particular question.
yeah, I have no problem with that. Members, we are out of session. And Ms. Bass, you were recognized to answer that question.
The fire marshal, I've spoken to them about this bill. Taking away the mayor's signature, they still have to process the application, if I'm receiving your question correctly.
Chairman Vaughn.
Right, I know, that part I've got. My question, though, is, does that processing, and let's say they grant from the state fire marshal's standpoint, they say, hey, you're cool, your tent's not going to blow up, you got the appropriate safety measures, et cetera. Does that overrule a local jurisdiction that says, that's great, but you're still not complying with our local zoning ordinance?
Ms. Bass,
That's
you
my
recognize.
question.
In the particular situation with Lakeland, it is still not permissive, but fireworks are still offered there. Thus the language in the amendment where fireworks are offered. In Lakeland, let me just be clear, we're talking about Lakeland, but there are several other situations throughout the state where monopolies have been created by the locals because they have either circumvented the law or they have locally done this by, their local ordinances. Knox County has situations. I think there's a little place outside of Chattanooga rurally. This is just not about Lakeland. So there are various other situations throughout the state of Tennessee that have ended up like this. But in Lakeland, it would have to, it's still not permissive according to their local ordinance in Lakeland.
Chairman Vaughn.
So if you wanted to, so this bill has nothing to do with you wanting to sell fireworks in Lakeland? That's what I'm trying to, that's what
I would love to.
Ms. Bass, you're recognized.
I'm sorry. I would love to sell fireworks and open up competition to others in Lakeland. But what I'm trying to do is create a fairness in the code to all other small business owners who have faced the situation of monopolies.
Chairman Vaughn.
Thank you, Mr. Chairman, but I still haven't gotten the question of how this will, if the state fire marshal has the ability to override state or local zoning that prohibits this from happening, because love our mayors and the administration of all these places, but they don't have the arbitrary decision to dictate. They have to rely on their own local codes and ordinances. And so I don't understand how this will accomplish letting you sell fireworks in Lakeland unless that fire marshal application overrides and supersedes what's going on in the local community. Because if this is just a situation to where we're going to streamline the process and we're going to not have to chase an elected official or bureaucrat, depending upon whatever the circumstance may be, what you're trying to get signed, that's somewhat of a disinterested party, I understand that. I understand for making the process more efficient. But if you're saying, hey, we're not going to let you sign off on this because we found a way to usurp your local codes and ordinances, that's what I'm struggling with on this. So that's my concern.
Ms. Bass, you recognize.
Within the code, all local ordinances still have to be in compliance. For your state permit to be accepted by the state fire marshal's office, all local ordinances still have to be complied with. So they cannot accept an application without the zoning, without the local ordinances being complied with. So they do have to do that checking.
All right. Any question for Ms. Bass? We have Speaker Marsh. You're recognized.
Do these places take bids from the companies? Like if there are two fireworks companies wanting to serve Lakeland, does the city say, we'll take bids and whoever's going to, or they charge them to sell?
Ms. Bass, you recognize?
No, they can charge local permits, but we haven't had instances, this has gotten so, it's become such a conflict through the years. We have had mayors leave the permit sit the whole entire time on the desk because they haven't wanted to sign it for people they don't like. And then they get stuck with their product through the whole entire season and don't get to sell it. We've had circumstances like that. We have had mayors that are in the fireworks business who want to be vindictive and don't want to sign other people's permits. This has just been problematic for decades. And we had mayors who wrote this bill back in the 1950s who were in the fireworks business who just said, you know what, we don't run to sign some permits, we don't have to. And that's how we got this code originally.
Speaker Marsh?
Well, if we didn't have this, would we have maybe tens or 100 companies selling in one area?
Ms.
Or
Bass,
would
you
the fire-
recognize?
Or would the fire marshal make a determination of how many is too many?
We really need to redo our code, Chairman Marshall, and get a limit in some of these areas. But right now, there is not. But local ordinances still have control on making limitations to how much is too much.
Okay, thank you.
Members, we're out of session. We're hearing from Ms. Bass. Do we have any other questions for her? If not, we're going back into session. Representative Miller, I do want to say, as I'm hearing this, I can't help but wonder if, and I think Speaker Marsh kind of alluded to this, is that a lot of local governments, perhaps they don't want those tents set up everywhere. I know a lot of cities, they can get to be problematic where they set them up and they want to control the supply of them. And could it be that they're simply letting the one company that has been doing it over the years come back and since they have an established relationship with them? I'm pondering that, but you're recognized. You look like you've got a response to that.
Well, I think the response has already kind of been answered by both the opponents and the proponents of the legislation, in the sense that local ordinances still has that control to limit the tents, I would think. And it gets back to this bill is saying to one mayor or some other mayors that you cannot run a monopoly based on the power of your pen. And I try to keep it as simple as that, because that's what we're really talking about. And when Chairman Vaughn talked about local control is still in place, local ordinances is still in place, the number of tents and the number of businesses that would be allowed to compete, and not through a bidding process, but just the idea of competing. You pay your fee and say, I want to compete, but you're being told, no, we are limited to who I choose, and that's where we are on this.
All right. Members, do we have any other questions for the sponsor? If not, we are voting to send House Bill 1136 as amended to full commerce. All in favor say aye. Aye. All opposed say no. No. Members, let's do a roll call on that one.
Representative Alexander. Burkhart. Clemens.
Aye.
Hale. Holsclaw. Johnson. Marsh. Thompson. Vaughn.
No.
Vital. Zachary.
No.
Chairman, you have 8 ayes and 2 nays.
The ayes have it. Sir, we'll see you next week in full commerce. All right, members, next up is item number 2. That's House Bill 1291 by Representative Parkinson. We have a motion, we have a second, and Representative Parkinson, I'm showing an amendment. What are you showing there?
I'm showing an amendment also, Mr. Chair. I have 3959. Is that what you have?
That's what I'm showing as well. Members, can we get a motion and a second on the amendment? We have a motion, we have a second on the amendment. And does that make the bill, or is that just minor?
It makes the bill, Mr. Chair.
Okay, let's go ahead and put that amendment on the bill. Members, we're voting to put Amendment 3959 on House Bill 1291. All in favor say aye. All opposed say no. The ayes have it. Sir, we are back on your bill as amended, and you are recognized.
Thank you, Mr. Chair and committee. This bill was brought to me by Senator Agberry. And I would also add that this bill is passed unanimously in the Senate without any opposition. The bill does three things. First, it authorizes the Board of Cosmetology and Barbers Examiners to reinstate an expired cosmetologist, esthetician, manicurist, natural hairstylist, master barber, instructor, technician license that has been expired for more than 3 years but less than 8 years. Secondly, it requires such persons applying to be in good standing with the board and to have been licensed to practice for 20 or more years. Lastly, the bill authorizes the board to waive reexamination or additional education requirements or to prescribe reasonable conditions for the applicant to meet, including an additional fee for reinstatement of license. The bill came from constituents because of COVID. They missed the opportunity to renew their licenses. They had been barbers and cosmetologists for decades, and they didn't want to have to take the examination again because, unlike other professions, there are no continuing educations. So there is no additional information that would have been missed out on by not receiving their license. And further, the board has the opportunity to charge them for the year that they did not renew their license. And with that, Mr. Chair and committee, I renew my motion.
Thank you, sponsor, for that explanation. Members, you've heard the explanation. Do we have any questions for Representative Parkinson? Chairman Vaughn, you are recognized.
Yes, thanks. Thank you, Mr. Chairman. Sponsor, what's the practice for if your license has expired just less than 3 years?
You recognized.
I think they can renew it. They can renew their license if it's expired for less than 3 years. But I think it was after 3 years, if I'm not mistaken, and we might need to go to legal on this. But if I'm not mistaken, I think it was after 3 years, you'd have to go back through school and take the courses over again.
And the premise here is that if you've been cutting hair for 20 years, you ain't forgot it.
Exactly.
Roger that.
Yeah.
All right, and we did, while you were doing that, I checked with legal, and you're correct on that. That's how it works. Members, do we have another, Speaker Marsh, you recognized?
I'd like to ask the representative, just because the Senate passed, does that mean we automatically should pass it?
Representative Parkinson, you recognize.
Thank you, Mr. Chair. Mr. Chair, when I looked at that in my notes, I actually paused for a second to consider whether or not I should say it or not. But thank you.
I was thinking the same thing, Representative. That may not help you over here in this chamber. Members, any other questions? Representative Holsclaw.
Thank you, Chairman. And the question I have, what is the fee per year they pay?
Representative Parkinson, go ahead.
That's a good question. I honestly don't have the answer for renewal fees. I think I may be mistaken. It's either like $60, I think.
You're the king of the hairdo?
Right, but I'm not licensed. I just slept in the Holiday Inn, Mr. Chair.
Okay.
Members, we have any other questions for the sponsor? If not, we are voting to send House Bill 1291 as amended to full commerce. All in favor say aye. All opposed say no. The ayes have it. Sir, we'll see you next week in full commerce.
Thank you, sir. Thank you, committee.
Next up is item number 4, House Bill 379 by the birthday boy. We have a motion. We have a second. Representative Beck, I do not see any amendments, so you are recognized on the bill.
Thank you, Mr. Chairman. And first of all, I'd like to thank the chairman from the District of Champions and the chairman of this committee. Last year, you worked with me to allow me to bring this late bill of Dallas's Law, where we had a young man killed down on Broadway, and to correct that. But unfortunately, we had a couple of unintended consequences. This bill does 3 things. Number 1, Dollywood and some private universities that have liquor license. In the bill, it says their security guards are to be unarmed under a PSO, and we're going to change that. They carry pepper spray and other little things, so to bring them into compliance, we're going to eliminate that. And number 2 is the definition of employee under the bill. Employee does not affect security companies that you've contracted out to for security. So this would allow that the subcontracting security company not to be termed as an employee. And number 3, from hospitality, is that front desk people who occasionally make perimeter walks to make sure everything's okay in the hotel, that they're not considered security personnel. So those are the 3 things that this, and I know we say clean up a lot, but this is truly a cleanup bill, Mr. Chairman.
Well, Representative Beck, we appreciate your description of this, and we realize that we actually don't have this bill in the right posture yet. It looks like there actually is an amendment. And what drafting code are we getting a motion in a second on? What are you showing, Representative?
I'm showing
5984?
005984.
That's what I'm showing. It does have a motion. It does have a second. Let's go ahead and get that on the bill. All in favor say aye. All opposed say no. The ayes have it. Okay, we are on your bill as amended. You gave a great explanation of it, but let's wait just a second and see if we have any questions from the committee. Speaker Marsh, did you have anything? Do you want to ask a question? Okay. Well, the question's been asked. Speaker Marsh has called the question on the bill. Without objection, members, we are voting to send House Bill 379 as amended to full commerce. All in favor say aye. All opposed say no. The ayes have it. Happy birthday. We'll see you next
I
week in
appreciate
Commerce.
the present.
All right, members, that moves us to item number 7 by Chair Lady Rudder. You're recognized. We have a motion. We have a second. Sponsor, you're recognized on your bill.
Thank you, Mr. Chairman and committee.
Oh, stand by just a minute. We actually do have an amendment. That's amendment. Are you showing drafting code 5788?
I am.
Okay, can I get a motion in a second? We have a motion, we have a second. Does the amendment make the bill?
It does.
Okay, let's go ahead and put that on the bill. Members, we're voting to put amendment 5788 on House Bill 919. All in favor say aye. All opposed say no. The ayes have it. We're back on your bill as amended, sponsor.
Okay, this is a simple little bill brought to me by my utility district that seeks to eliminate 2 consecutive term limits, which has been imposed on that utility district. And per their request, they would like for this to be to eliminate those 2 consecutive term limits, and therefore they would not have term limits. They are having trouble finding commissioners to serve, and this would only affect Marion and Franklin counties.
Okay, members, you've heard that explanation. Do we have any questions for the sponsor? If not, we are voting to send House Bill 919 as amended to full commerce. All in favor say aye. All opposed say no. The ayes have it. We will see you next week in full commerce.
Thank you, Mr. Chairman and committee members.
He's on the special calendar. Are you sure? Yes. Okay. Members, we're going to go out of order real quick, and we're going to actually have Chairman Howell come up, and that's, if you're looking at your calendar, that is item number 6, and that's House Bill 655. We have a motion, we have a second, and Chairman Howell, I am showing a couple of amendments. What do you have?
Mr. Chairman, I have an untimely filed amendment which actually makes the bill.
Okay. And what we're going to do, you've explained what your amendment does. We don't take untimely filed amendments, but it simply changes the threshold a little bit. Why don't you go ahead and run the bill? This is our last meeting. God willing, we're not going to open this committee up next week.
I was hoping you'd
And
say
so
that.
I have consulted with Chairman Vaughn, and because of the water leak and everything, we're going to allow this to pass on to full. The amendment's not substantial enough. I mean, it makes the bill, but it doesn't differ that much from the amendment that you had previously filed. So one of the amendments you did properly file, is that right?
I did, yes. That was amendment, 5768, I believe. Sir.
Okay, let's go ahead and adopt that one now, since that
Okay.
would make the bill. It
Yeah.
was timely filed, and we'll let you file a proper amendment in full committee. We have a motion, we have a second. Members, that is on Amendment 5768. Let's go ahead and put that on the bill. All in favor say aye. All opposed say no. The ayes have it. Chairman, we are on your bill as amended.
Okay. The amendment we just adopted actually needs to be amended in full. So if I may, with the committee's indulgence, explain what the amended bill will do. Is that okay?
That sounds good, Mr. Chairman.
I asked for House Bill 655 to be drafted following a conversation that I had with some home remodelers in my district, and I understand there are other districts that are struggling with this same issue. They're trying to make a living, and all this bill does is increase the cap from $29,999 to $50,000. The reason for this is because these home remodelers' limited license has been capped for 29 years. It's been capped at $24,999. You know what's happened to the economy in 29 years. Ran a little, actually I had some assistants from the Beacon Center, and they ran some numbers for me. That $24,999 is now the inflation equivalent of $42,000. A home remodeler back in 1994, I believe, was when this cap was put on. That's 29 years ago. They could remodel a kitchen, remodel a bathroom, and put a roof on, or maybe a floor for $24,999. You can't do a kitchen for that now, not a decent kitchen. And so they're losing work, and you couple that with the fact that I have in my district, I assume you do too, you have people who are homeowners who have decided it's cheaper to remodel than it is to buy or build. And so they have remodeling work that is going to come somewhere in between $35,000, $45,000. But because of the cap, they can't find anyone to do that work. And the builders who are building homes are not going to stop building a house to go do a $35,000 job. They're just not going to do it. And so what this bill does is simply just changes the cap. It doesn't do anything. If we don't pass this bill, nothing happens. If you do pass this bill, nothing happens, except it increases the cap. So that's what happens if we're able to put this amendment on in full, Mr. Chairman.
Thank you, Chairman, for that explanation. Members, do we have any questions for the sponsor? You do. Representative Burkhart, you recognized.
Yes, sir. Thank you, Mr. Chairman. Does this include plumbing, electrical, and everything, or just carpentry?
Chairman, you recognize.
Let me first preface it by saying that this language was drafted with the assistance of the Department of Commerce, who oversees all the licensing from these limited license caps to the unlimited license, which goes into the millions and millions of dollars. And so at their suggestion, they wanted to put the LLEs, electrical, and LLPs, plumbers, in here because they regulate them too, and they have the same cap. So they said it was much easier to regulate, and they still have the license as well. So at their suggestion, that's what we did.
Okay. Representative Burkhart, you recognize.
Thank you, Chairman. And I just have a comment. As a licensed contractor that I've had since 1985, and I've spent probably $50,000 to $100,000 staying a licensed contractor with the state. Just recently, every 2 years, I have to spend $5,000 to $10,000 to have my license renewed, and not that I say that to say that as the people who who study for these tests and do these things, and then to have this just raised to $50,000. I understand the concept. I get it, but also, I've sat on this committee for a few months now and learned a lot. That we give license for eyebrows and everything else, and to have somebody come in and wire your house and not have a license kind of doesn't make a lot of sense to me. So I'm struggling with going up to $50,000. electricity is something that somebody needs to know what they're doing, and in any remodel. But probably one of the other things that bothers me about it is we're only going to be bonded at 40%. I know now they're only at 40% bond, and I don't understand that rationale at all. I would be better off. I think I could understand it better and could live with it more if they were required to be at 100% bond on the job. So anyway, thank you.
Chairman Howie recognized.
Thank you. Thank you for those comments. I appreciate your thoughts. With regard to the bonding, it has been at 40%. $10,000 is what 40% of $24,999 is. It's been that way for, I guess, 29 years. And so everyone who was the stakeholders in this agreed, including the Department of Commerce, agreed that we would keep it at 40%, which raises it to $20,000. But it does not mandate that that be the maximum. It's open-ended. I think it says a minimum of 40%. So the agency that has the rulemaking authority can increase that by going through GovOps and increase that. But since we didn't want to deal with that in this bill, since it's at 40%, we left it at 40%. I might also say that the Tennessee Home Builders Association is not opposing this bill. I've talked to them several times. I talked to the president yesterday. They didn't have time to meet as a board or a body, but she said, as far as she knew, there was no opposition from the Tennessee Home Builders Association. The general contractors of Tennessee are not opposing it. They had input into this bill. The commercial contractors, Nathan Ridley represents them, they are not opposing it, and the Department of Commerce is deferred. So this is a small business bill, small business friendly bill. It simply allows these small businesses to continue to make a living in this economy, which is not treating them very well.
Thank you, Chairman. Members, do we have any other questions for the sponsor? If not, we are voting. We're voting to send House Bill 655 as amended to full commerce with the expectation that he will amend it properly in full commerce. All in favor say aye. Aye. All opposed say no.
No.
The ayes have it. Let your noes be registered with the clerk if you want. And, sir, we'll see you next week in full commerce.
Thank you, Mr. Chairman and committee.
We're going to take another bill out of order. I'd like to have Representative Butler come on up. That's number 9. Members, we're moving to item number 9, and that's House Bill 280 by Representative Butler. Can I get a motion in a second? We have a motion. Can I get a second? We have a second. Representative Butler, you are recognized on your bill.
Thank you, Committee and Chairman. This bill simply raises the commissioner pay from $300 to $500 for boards in Morgan and Roane County, specifically Cumberland Utility District, Plateau Utility District, Roane Central Utility District, and Watts Bar Utility District. So it only affects those 4 utility district boards and does not affect any other compensation they receive other than the monthly rate or the meeting rate from $300 to $500. And with that, I'll stand for questions and renew my motion.
Thanks, sponsor, for the explanation. Members, do we have any questions for the sponsor of the bill? If not, we are voting to send House Bill 280 to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it. Sir, your bill goes to full commerce. See you next week. All right, members, that brings us to some members of this committee and to item number 11. That's House Bill 802 by Speaker Marsh. Can we get a motion and a second for the speaker? We have a motion. We have a second. And Speaker, it looks like you do have an amendment. Can you tell me what drafting code you're showing?
Yes, sir, Mr. Chairman. It's 5165.
That is what I'm showing. Do we have a motion and a second? Motion. We have a motion. We have a second. Speaker Marsh, does that make the bill or is it minor?
It makes the bill.
Okay. Let's go and put it on the bill. Members, we're voting to put Amendment 5165 on House Bill 802. All in favor say aye. Aye. All opposed say no. The ayes have it. Speaker, we are back on your bill as amended, and you are recognized.
Thank you, Mr. Chairman. This bill is from the Tennessee Public Utility Commission. This House Bill 802 amends the Underground Utility Damage Prevention Act to clarify definitions and procedures to provide safer evacuation practices around underground facilities. It defines hand digging, it defines white lining of the boundaries of the area proposed for excavation, and it authorized Tennessee 811 to collect data for large project excavations in order to recommend possible alternative notice requirements for such projects. With that, I'll answer any questions.
Members, you've heard the explanation from Speaker Marsh. Do we have any questions for him? Seeing none, members, we're voting to send House Bill 802 as amended to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it. Congratulations, sir. We'll see you next week in full commerce. That brings us to item number 12. That's House Bill 798 by Speaker Johnson. We have a motion. We have a second. Speaker, I'm showing an amendment. What drafting code?
Mr. Chairman, 4788.
Thank you, Speaker. That's what I'm showing as well. We do have a motion. We have a second. Speaker, does that make the bill or is that minor?
It makes the bill.
Okay, let's go ahead and put it on the bill, members. We're voting to put Amendment 4788 on House Bill 798. All in favor say aye. Aye. All opposed say no. The ayes have it. Speaker Johnson, you are recognized on your bill as amended.
Thank you, Mr. Chairman. House Bill 798 as amended increases the number of board members on the Executive Committee of the Underground Utility Damage Enforcement Board from 3 to 5.
Thank you for that explanation, sponsor. Members, do we have any questions for the sponsor? If not, members, we are voting to send House Bill 798 as amended to full commerce. All in favor say aye.
Aye.
All opposed say no. Ayes have it. Speaker Johnson, we'll see you next week in full commerce.
Thank you, Mr. Chairman.
Members, that brings us to item number 13. That's House Bill 1063 by Chairman Vaughn. We have a motion, we have a second, and Chairman Vaughn, I do show an amendment.
Yes, sir, Mr. Chairman, but while sitting here, I have thought about my colleagues and how their time is so valuable, about how there's many other things that we could be pouring forth these fonts of knowledge upon. Plus, my speaker's bill sponsor is not moving the bill, so I'd like to take this off notice until first part of next year, if that's allowed.
Chairman, is that a roll to next year, or do you want it off notice?
Yeah, it's the same.
Which one? Okay.
Let me take it off notice, and I'll put it back on notice next year.
Sounds good. Members, without objection, House Bill 1063 is off notice. Members, that brings us to item number 14. That's House Bill 1305 by Representative Thompson. We have a motion, we have a second, and Representative Thompson, I show a couple of amendments there. What you got?
Let's see, the one I think we want to approve is the one with drafting code 6178.
Okay, members, that's drafting code 6178. Can I get a motion in a second? We have a motion, we have a second. Representative Thompson, you are recognized on your amendment. Does that make the bill, or is that just minor?
It's somewhere in between. It makes some changes in sections 2 and 3 of the bill.
Okay, let's go ahead and put it on there, and you can describe the bill as amended. Members, we are voting to put Amendment 6178 on House Bill 1305. All in favor say aye. Aye. All opposed say no. The ayes have it. Representative Thompson, you're back on your bill as amended. You are recognized.
Thank you, Mr. Chairman. The House Bill 1305 is a small amendment to the Uniform Landlord-Tenant Act. Currently, a landlord or landlord's agent is required to give their name and address only, and not necessarily a physical address, in writing to the tenant at or before the rental agreement is made. This bill, as amended, requires a little bit more information. It will include the name, telephone number during business hours, a 24-hour emergency telephone number if different, office email address, and a maintenance email address if that's different, and a physical address. Now, the reason most landlords do the right thing for their renters, but I've received numerous complaints in my district and from other people too outside of my district from tenants not being able to locate or receive the service from the landlord. And, when heating goes out or a pipe bursts, a family needs help and they need to contact a responsible party immediately. Part of the reason might be the proliferation of out-of-town and out-of-state and foreign investors coming in, buying property and not really maintaining them like they should, and other reasons too. The bill will not totally solve the problems, but it'll help responsible tenants when they're faced with those minority landlords who do not fulfill their obligations under law. The Tennessee Apartment Association and the Tennessee Realtors are neutral in this bill as amended. And that's essentially it. I'll be happy to take any questions or comments.
Thank you for the explanation. Chairman Zachary, you recognize.
Thank you, Mr. Chairman. Sponsor, just to make sure I'm clear, so currently, as the law states today, a landlord, if I personally own 3 condos, there's no requirement for me to give my physical address to a tenant. If this bill passes, there would then be a requirement for me to either provide a personal physical address or a business address to a tenant, correct?
Representative Thompson.
That's correct.
Thank you, Mr. Chairman. And for that reason, sponsor, I can't support the bill. I know many landlords who have multiple condos, and depending on the type of tenant they serve, they would not want them, because of eviction practices and others, they wouldn't want them to have their physical address. And so for that, I can't support the bill. Thank you, Mr. Chair.
Members, any other questions for the sponsor? If not, we are voting members to send House Bill 1305 to full commerce as amended. All in favor say aye.
Aye.
All opposed say no. No. Noes have it. Bill fails. Next up is item number 15. That's House Bill 52 by Representative Hale. Do we have a motion and a second? Second. We have a motion. We have a second. Representative Hale, you are recognized.
Thank you, Mr. Chairman. House Bill 52, the reason I brought this bill is because I have a constituent who is still resolving a disputed survey. He believes that if they were made aware that the survey was to be done, that they could have communicated with the surveyor and avoided the legal fees to resolve the incorrect survey. My goal with this legislation was to codify what is already considered a best practice in many in the surveying industry prior notification to adjoining property owners when a survey is to be done. Surveyors have a difficult job, and I appreciate very much what they do. My constituent and I believe that there would be less of a chance for future property disputes if we pass this type of legislation. This idea is not new to the surveying industry. For example, TDOT requires a surveyor to contact adjoining property owners. Other states, such as Texas, Kentucky, Mississippi, require a notification of adjoining landowners. Furthermore, surveyors' standard practice requiring that the adjoining property owners' information be included in the final survey, so it's information that they must already collect. This legislation would say that they must let these folks know that a survey is being done, which could impact their property lines. Surveyors have the right to access others' property when doing their job. It was never my intention to change this. In fact, throughout our negotiations, we tried to come up with a way to create protections for surveyors who may face refusal when trying to gain access onto property. I want to thank the stakeholders that have worked vigorously on this, on a compromise amendment that would have worked both for the surveyors and the property owners. However, we could not come up with one, so I would like to take this bill off notice where we could work on these issues through the summer.
So thank you, Mr. Chairman and committee.
Thank you, Representative Hale. Members, without objection, House Bill 52 is taken off of notice. Members, that brings us to item number 16. That is my bill, so I'm going to hand the gavel off to Chairman Vaughn.
Thank you, committee members. We're now going to take up, I believe this is a somewhat emotional moment, perhaps the last bill of this version of Business and Utilities. It's House Bill 1276 by Chairman Boyd. Motion. All right, got a motion and an amendment. A motion and a second. We have Amendment 6120.
Motion.
All right, let's get, it rewrites the bill, let's get it on there. All those in favor of approving House Bill, or House Amendment Drafting Code 6120, please signify by saying aye.
Aye.
Any opposed, no. The ayes have it. Chairman Boyd, you're recognized.
Thank you, Mr. Chairman, committee. Members, House Bill 1276 deals with retainage. And retainage, if you're not familiar with that, it is when an owner does a construction project, they hold back 5%, or can hold back up to 5%. It's held in a escrow account at a financial institution, and it is paid when the work is complete. Over the years, there has been, in some cases, a reluctance on the part of the owner to release that retainage to the general contractors and the subcontractors. And what this bill does, and just to let you know, there was collaboration done between the subcontractors, the associated builders, and everyone seems to have gotten in a good spot on this. But, Mr. Chairman, well, let me finish telling you about the bill. It clarifies that if an owner withholds retainage, the general contractors and subcontractors do not have to withhold additional retainage from their own subcontractors. It increases the current penalty for failing to deposit retainage in an escrow account that complies with the Prompt Pays Act requirement from $300 per day to $500 per day. And an owner must currently release all retainage within 90 days of substantial completion, but this section imposes a 500-day penalty on the owner, not the financial institution, but the owner, if retainage it does not comply with and is not released, which is obligated under the Prompt Pay Act. And it introduces a procedure for the release of retainage prior to substantial completion of the project if the specific contractor's work is substantially completed. Mr. Chairman, I do have a few people here that would like to testify if you wouldn't mind going out of session.
I'm just happy as can be. So without objection, we're heading out of session. And so if you folks would come down, introduce yourself, sit down there, and there's a microphone with a guy that's got some parentheses in front of his mouth. Just punch that and you'll be live. And we are out of session.
Good afternoon. My name is Jay Wallace Irvin. I'm a lawyer here in Nashville, Tennessee, and I practice construction law. And then,
I'm sorry, and I'm Jason Hale, part of the Tennessee Subtractors Association, part of the executive board.
I think in this instance, Representative Boyd did an excellent job explaining this bill. It does four primary things. In Tennessee, owners are allowed to withhold up to 5% retainage on a construction project from a general contractor as progress payments are made throughout the life of the project. If those payments are, once the project is actually completed or substantially completed, an owner's obligation to release those funds to the general contractor arises. There is written contracts between the general contractor and the owner can extend that timeline up to 90 days pursuant to the Prompt Pay Act as it exists currently. But at 90 days following substantial completion, an owner is required to release those sums to the general contractor so they can release it to their subcontractors, so the subcontractors can release it to their suppliers and on down the contracting chain. The problem that currently exists is there is actually no penalty or no damages to an owner if they don't release the retainage within 90 days. And what we are seeing is many owners just don't release it. And so what the contracting community has said is there needs to be some sort of statutory incentive to encourage owners to comply with the law as it currently is, which is the $500 a day in damages that would be payable to the contractors as a result of an owner's failure to release those sums. The second aspect of this is a clarification that a general contractor does not have a separate obligation to withhold additional monies under the Prompt Pay Act. The Prompt Pay Act is drafted in a way that if an owner withholds 5% from the general contractor, that 5% includes all of the retainage that would be withheld on a project. So a general contractor or a subcontractor is not required to withhold additional monies from their own subcontractors in that instance. In terms of Section 2 with the escrow penalties, all retainage must be placed in a separate interest-bearing escrow account with a third party. The idea of that is that Tennessee is a trust fund state, so at the time the retainage is withheld, it is withheld because it has already been earned by the contractors. So at that point, it becomes the money of the contractor to whom it is due. That money is supposed to be set aside in a third-party account so that everybody understands the separateness of that money and those funds. Currently, there's a $300 per day penalty if an owner does not place those retainages in the separate interest-bearing escrow account. The idea with Section 2 is to make those penalties uniform across the Prompt Pay Act and have it as a $500 per day penalty that would be payable by an owner. The final section of this bill is an early release procedure, or introduces an early release procedure. A lot of times, as is very often the case here in Nashville, construction projects can last multiple years. There are several instances, for instance, with site contractors who do the initial dirt work or earth moving to get a site prepared for a construction project, that they do their work under a separate permit, a grading permit, that's not actually tied to the building permit itself. The grading contractor performs its work, completes its scope of work, substantially completes its scope of work, but it still has to wait, in some instances, 3 to 4 to up to 5 years before they actually have an opportunity to have their retainage released, because the obligation to release retainage does not arise until the project as a whole is substantially complete. So what this process does is give contractors like that, whose work is completed before the project, an opportunity to have similar opportunities to show that their work is substantially complete so that they can obtain the release of retainage prior to the final release of retainage upon substantial completion. And that in a nutshell, is a very quick overview of this bill, and I'd be happy to answer any questions should the committee
Thank you,
have
sir.
any.
Do we have questions? I see a couple. Chairman Marsh, Speaker Marsh.
Thank you, Mr. Chairman. So you're saying now you're having all kind of problems with people releasing the retainage, and under this, how would you work that? Would you bring suit against them for their judgment? And is there a provision who pays the legal expense?
You're recognized, sir.
Thank you, Mr. Chairman. Yes, currently the Prompt Pay Act in the 600 sections allows for different types of relief. You can either get injunctive relief, an order from a court requiring a release, but again, that still requires a contractor to take action on their own. The second is you can just file a Prompt Pay Act claim, and as part of that, after a trial, if you can show bad faith of an owner, meaning a conscious disregard of rights, whether it's statutory or contractual, there is an option for a court in their discretion to award attorney's fees.
Representative Burkhart.
Thank you, Chairman. Is that $500 per day per subcontractor?
If I can ask your question, in terms of the existing law, there is a current obligation that an owner establish a separate interest-bearing escrow account prior to withholding any retainage from the contractor. The current penalty for that is $300 per day. That is in my opinion, as a construction lawyer, an aggregate penalty that is payable only to a general contractor. The separate part of this bill, in terms of the release of retainage, is a $500 per day penalty to each owner. So if there are 3 subcontractors that separately have to file suit, each subcontractor would be entitled to that penalty, as would a general contractor.
Representative Holtzclaw. Okay, you good? All right. Well, if we have no further questions for our guests, Chairman Clements.
This is for you, Chairman Vaughn. I just wanted to point out, as y'all can all tell, this is a very well-spoken and brilliant legal mind over here, because he received his legal education at the best law school in the state of Tennessee, near the District of Champions, Chairman Bond. And he had a certain classmate on this committee who will remain nameless, who was not as good of a law student as he was, but just wanted to point out that, Mr. Chairman. So I thought you'd appreciate that. Might help Chairman out with his vote here.
Thank you, sir. Those Humphreys lawyers are everywhere we look. So without any other questions for the knowledgeable man from the University of Memphis State University. We're back in session. Any questions for the sponsor? Seeing none, hearing none, we're going to vote on House Bill 1276 as amended. This will send it to full commerce. All those in favor, please signify by saying aye. Aye. Any opposed, no. The ayes have it. And back to you, Chairman.
Thank you, Mr. Chairman. And members, we are going to dispense with the special calendar because we've addressed all those bills. So without objection, the special calendar is dispensed with. And House Bill 1137 is off notice. And Speaker Marsh, you're recognized.
Thank you, Mr. Chairman. I just want to brag on what a great job you've done this year. You've run it very efficiently and loud, and you beat the gavel very loud. You've done a great job. I'm impressed.
Thank you, Speaker Marsh. I appreciate that. Which brings me, members, this is our last meeting of 2023, subject to the call of the chairman. But I want to thank a few people real quick. We appreciate our research analyst, Owen Rosenberg, for doing such a great job this year. This is his first year as a research analyst. We appreciate our incredible legal mind here with Lovin Middleton Dunn, and we've had Doug Garrett in here as well. We appreciate you guys and just the knowledge that you bring to it. We appreciate Joey Barnett, my legislative assistant, who has functioned as the committee clerk in here. He's done a great job this year, and thank you so much for that. And our Sergeant at Arms, Mr. Wayne Hawkins, thank you, sir, for your service. And then our clerk and intern was Brett Howard from Tennessee Tech University. And just like I said, guys, appreciate this committee and just how well we've got things done this year, and have enjoyed working with each and every one of you. And so unless we get called back, subject to the call of the chairman, this committee is adjourned for the year.